The day my mother-in-law slid a revised will across my kitchen table and told me my name had been removed, I did something that confused her deeply. I smiled. Not the polite, swallowed kind of smile you learn to make at difficult family dinners. A real one. The kind that comes from somewhere deep and quiet, the same place I go when a courtroom argument starts to fold exactly the way I'd planned. Because what Margaret Eloise Calloway didn't know, what she had never once thought to ask, was that for 31 years I had made my living reading documents exactly like the one sitting on my kitchen table. And this one had 4 problems so fundamental, so amateurishly wrong, that I almost felt sorry for the notary who'd put their stamp on it. Almost. I'm Diane. I'm 62 years old. I spent my career as an estate planning attorney, 31 years handling wills, trusts, probate disputes, and the particular kind of ugliness that surfaces in families when a patriarch dies and the money suddenly needs a new home. And my mother-in-law had just handed me the worst forgery I'd seen in 3 decades of practice. This is the story of how she learned that removing a lawyer from a will is significantly more complicated than removing her from the guest list. Let me take you back to the beginning, because this didn't start with the will. It started with a man named Gerald Calloway and the way his family handled the fact that he loved me. I met Gerald at a conference in 1989. He was an accountant then, quiet, methodical, the kind of man who remembered every number and forgot nothing. We were seated at the same table for a panel on estate tax reform, and he asked me 3 intelligent questions in a row without once checking his phone, which in 1989 meant he was simply a man who was paying attention. That was enough for me. We married 2 years later in a small ceremony. Gerald's mother, Margaret, attended in a hat that cost more than my dress and spent the reception telling people she'd hoped he'd marry someone from the club. She meant it kindly. That was the worst part. Margaret didn't dislike me personally. She simply couldn't file me anywhere in her mental registry. I wasn't from old money. I wasn't from her church or her county or her particular tier of Southern respectability. I was a woman who worked, which in Margaret's worldview was something you did if your husband hadn't done his job properly. For 30 years, we negotiated a kind of armed peace. She was never cruel. She was never warm. She sent birthday cards that arrived 3 days late and called my profession Diane's little law practice at every family gathering. Gerald defended me in his quiet way, redirecting conversations, squeezing my hand under tables, once telling his mother quite plainly that Diane is a better attorney than anyone you've ever retained, mother, which she received with a tight smile and promptly never mentioned again. We had 2 children. A son, Thomas, who works in environmental policy, and a daughter, Claire, who manages a gallery in Charleston. Both of them, I say without apology, are excellent people. Gerald's father, Robert Calloway, had built the family's money the old-fashioned way. 40 years in commercial real estate, compounded carefully, never borrowed more than he could sleep with. When he died in 2009, he left behind a trust that was, professionally speaking, a well-constructed document. Gerald and his brother Richard each controlled half. Margaret had lifetime income rights. There were provisions for grandchildren. I had helped Gerald review it when Robert first established it in the early 90s, as a professional courtesy. Margaret didn't know that. She assumed the only person in the family who understood the document was the attorney Robert had hired, a man named Foster Hines, who had since retired to a golf community in Hilton Head. That assumption would matter later. Gerald was diagnosed with Parkinson's in 2018. It moved slowly at first, a tremor in his right hand, some mornings worse than others. And then, as it always does, it moved faster than we'd prepared for. By 2021, he needed help with most daily tasks. By 2022, he was in a facility 20 minutes from our house, which I visited every day without exception. Those were the years that showed me who people were. Margaret came on Sundays when the facility had fresh flowers in the lobby. She brought food Gerald couldn't eat anymore and talked about family matters over his head as though he had already become furniture. She once asked me, in front of him, whether we'd thought about what would happen to the house. Thomas drove 6 hours each way every other weekend and read to his father from history books. Claire called every morning at 9 without missing a single day for 2 years. And Richard, Gerald's brother, the other half of the trust, started calling Margaret with increasing frequency about something he referred to, when I overheard it once, as restructuring options. I noted that, filed it the way I file things, the way you do when you've spent 30 years learning that a quiet conversation about money is never actually quiet. Gerald died on a Tuesday in March of 2023. He died in the morning, with Thomas on one side and me on the other, holding his hand. Claire was on the phone, her voice traveling the distance. It was, as these things go, as peaceful as loss can be. The will was straightforward. Gerald had updated it in 2020 with my assistance, and it distributed his half of the trust to our children equally, with a life income provision for me from our joint marital assets. It was the document of a man who had thought clearly and loved generously. I had a copy. I always had a copy. I'm an estate attorney. Margaret came to the house 3 weeks after the funeral. She brought Richard, which I noted because Richard had not come to the funeral reception. She sat in my living room in her good pearls and her late-day coat and told me, with the particular gentleness of someone delivering news they have rehearsed, that there had been a development. She placed a document on the coffee table. I looked at it without touching it, the way you look at something when you already know it has problems. It was titled, Last Will and Testament of Gerald Robert Calloway. The date on it was October 2022. It named Richard as the primary beneficiary of Gerald's trust share, with Margaret holding continued income rights. My children received modest personal bequests, furniture, sentimental items. My name appeared once, in a standard survivorship clause, stripped of any financial provision. Margaret explained, in her careful voice, that Gerald had updated his wishes privately, that he had felt, toward the end, that it was important for the family assets to remain within the Calloway bloodline, and that she hoped I would understand. I looked at the document. I looked at the date. In October 2022, Gerald could not hold a pen. I had the occupational therapy notes to prove it. He had not been able to execute a signature for 4 months by that point. The notary stamp was from a woman I didn't recognize. The witnesses were names I'd never seen. And there was a provision in the document that Gerald's actual attorney, the one who'd drawn the 2020 will, had specifically told us not to include, because it created a tax exposure we'd discussed at length and explicitly rejected. Nobody who had actually talked to Gerald would have written it that way. This was not an updated will. This was a document that had been manufactured by people who understood Gerald's intentions the way a forger understands a signature, as a shape to copy, not a meaning to honor. I looked up from the table. Margaret was watching me with something that might have been sympathy, or might have been the satisfaction of a woman who believes she's played the last card. I see, I said. I hope you won't make this difficult, she said. Gerald would have wanted peace. I thought about October 2022. I thought about Gerald's hands, which I had held every single day. I thought about the therapy notes and the facility records and the medication logs and the 12 people who would testify that in October of that year, my husband could not have signed his name to a grocery list, let alone a legal document. And I thought about the copy of the real will, the one dated 2020, that was sitting in a fireproof safe in my office, witnessed by 2 attorneys, filed with Gerald's legal team, and already in probate proceedings that Margaret apparently didn't know had begun. I don't intend to make it difficult, I said, in my most even courtroom voice. But I do intend to make it correct. She left 30 minutes later, still believing she'd won. That night, I called my daughter Claire. I didn't tell her everything. Not yet, but I told her to trust me, to give me 60 days, and to understand that her father's wishes were going to stand. She said, Mom, you're the most terrifying person I know. I'm not worried. I took that as a compliment and went to work. Here is what I knew before I made a single phone call. The document Margaret had presented had 4 fatal defects, and she had no idea that the person she'd handed it to had spent 3 decades finding exactly these kinds of problems in exactly these kinds of documents. First, the execution date. Gerald could not sign in October 2022. This was documented, clinical, and witnessed by a facility full of licensed medical professionals whose records are not subject to creative reinterpretation. Second, the witnesses. In our state, a will requires 2 disinterested witnesses, people who receive nothing under the document. One of the 2 names on Margaret's will was a woman who, as I discovered with 1 afternoon of research, was the daughter of Richard's college roommate. She was a beneficiary's social acquaintance at minimum, which in a contested probate proceeding is precisely the thread a good attorney pulls first. Third, the notary. I called the notary licensing board. The stamp number on Margaret's document was registered to a woman whose commission had lapsed 8 months before the document's purported execution date. An expired notary stamp doesn't automatically void a will in every circumstance, but in a contested proceeding, it becomes a piece of evidence about whether this document was executed with the care of a legitimate legal instrument or assembled by people who were working in a hurry. Fourth, and this was the one that told me the whole story, the document contained a specific clause that Gerald's actual estate attorney had explicitly advised against, a clause we'd discussed, rejected, and documented our rejection of in writing. For that clause to appear in a will allegedly signed in 2022, someone would have had to reconstruct Gerald's estate planning preferences without access to the 2020 file and guess wrong in a very specific, traceable way. The document hadn't been updated, it had been imagined, by people who thought a dying man's wife was too distracted by grief to read the fine print. I spent the next 3 weeks building a file the way I build every file, completely, sequentially, and with the assumption that every piece of it will eventually be read by a hostile expert. I pulled Gerald's facility records. Every nursing note, every therapy session, every medication administration record for a 6-month window around October 2022. I had standing to request them. I was his spouse and his healthcare proxy. I contacted Gerald's actual estate attorney, a woman named Patricia Holt, who had drawn the 2020 will and who reacted to Margaret's document with a silence that lasted almost 5 full seconds before she said, very quietly, "Diane, send me everything you have." Patricia filed the 2020 will into probate within days. The Calloway family's version had not yet been filed. Margaret, I think, had expected me to simply accept it. You could read that assumption in every line of how she'd presented it. She had come to my house. She hadn't sent a lawyer. She'd handed it to me like a finished thing. She had never once, in 32 years, asked what I actually did for a living in any detail. That is what happens when you see a person as a category. You stop updating your information about what they know. Thomas drove down when I told him what was happening. He sat in my kitchen for 2 hours reading through the file I'd built, and at the end of it he said only, "How does someone think this works?" "They think it works," I said, "because they assume the person on the other side will be grieving and overwhelmed and not know which questions to ask." He looked at me. "They made a poor assumption," he said. "Yes," I said, "they did." The probate proceeding opened formally 6 weeks after Gerald's death. Patricia filed the 2020 will with full documentation. The Calloway family, represented by an attorney from a firm I recognized as solid but not exceptional, filed their counter-document. And then Patricia, in the way of good litigators, began to take depositions. She deposed the notary first. The woman, who turned out to have had no idea her stamp had been used after her commission lapsed, which opened a separate question entirely, could not confirm she'd been present for the execution. Her memory of the event was vague in the precise way that memories are vague when they're being reconstructed, rather than recalled. She deposed the witnesses next. The first one held up reasonably well. The second, Richard's old friend's daughter, could not explain how she'd come to be asked to witness the document, gave 2 different answers about whether she'd been in the room when Gerald signed, and when asked to describe Gerald's physical condition at the signing, described a man who could hold a pen and speak clearly. This was October 2022. The nursing notes for that month described a man who could do neither. She deposed Richard. Richard, under oath, insisted he had no involvement in drafting or arranging the document. He simply said his mother had informed him of Gerald's wishes. He said this 17 times in various formulations. Patricia thanked him for his time. She deposed Margaret last. I was not in the room. Attorneys don't attend depositions of opposing parties as a general matter of professional courtesy. But Patricia called me the same evening. She held up through the factual questions, Patricia said. But when I asked her to describe Gerald's handwriting in the weeks before October and then showed her the occupational therapy records, she went very quiet. And when I asked her who had suggested the particular asset structure in the document, the one with the tax exposure problem, she said Gerald had wanted it that way. A pause. Gerald had explicitly rejected that structure in writing in 2020, Patricia continued. He'd signed a letter confirming it was not to be included. Margaret's attorney apparently was not aware of that letter. I held the phone very still. She testified, Patricia said, to something that is directly contradicted by a signed document in Gerald's own hand, which happens to be from a period when he could still sign his name. Margaret had just testified to Gerald's intentions, and Gerald himself had already told us otherwise, in writing, at a time when no one could question his capacity. The letter from 2020 wasn't secretly obtained or dramatically uncovered. It was in the original file. The file Margaret's team had never asked to see, because they'd assumed the 2020 will was simply going to be displaced by theirs without a fight. They had not modeled a fight. The proceeding took 4 months. At no point did it become what I would call dramatic. No courtroom confrontations, no raised voices, no climactic revelations in front of a gallery of onlookers. Probate is a precise and largely administrative process. You bring your documents, you contest the other party's documents, an expert examines them, a judge applies the law. The forensic document examiner was the clearest moment. She examined both wills under the professional standard, and her report on the 2022 document's signature was, and I am quoting from memory, inconsistent with the documented progression of the decedent's motor capacity at the purported date of execution. That is the precise way experts say. This signature was not made by this person on this date. The judge voided Margaret's document. Not because anyone called it a forgery in open court. That word carries criminal implications, and a civil proceeding doesn't require it. But because the document failed to meet the execution requirements under state law, because the decedent demonstrably lacked capacity at the purported signing date, and because the testimony in support of its validity was insufficient, Gerald's 2020 will was admitted to probate. Thomas and Claire inherited his trust share as he had intended. My marital provisions were honored as written. Richard retained his own half of the trust. That was never in question. Gerald's wishes had nothing to do with Richard's share, only with his own. Richard had been invited into an arrangement that didn't require his half, only his cooperation, and he had cooperated without apparently asking enough questions about whether the document he was supporting could survive scrutiny. He has not contacted me since the proceeding closed. I think he understands that I'm aware of how much he understood and when. Whether that matter goes further is something that remains open. Probate fraud referrals are not uncommon in my field. I have had that conversation with Patricia. We are watching the clock on certain statutes. Margaret called me once, about 6 weeks after the ruling. I almost didn't answer. When I did, she didn't apologize. She isn't built for apologies. She said only, "I suppose you had everything in order." "I always have everything in order," I said. "That's the job." A very long pause. "Gerald used to say that," she said finally. Her voice had changed. The marble was gone. What was underneath it was old and tired and, I think, genuinely grieving for a son she'd loved in the only constrained way she knew how. I felt the pull of something like sympathy. I let it exist for a moment without acting on it. "Margaret," I said, "Gerald wanted his children to have what he built. He wanted me provided for. He documented it carefully, with full capacity, 3 years before he died. Whatever you told yourself your reasons were, you tried to take that from our children. Not from me. From Thomas and Claire." Another pause. "I know," she said. It was the smallest thing. 2 words. But in 32 years, it was the closest she'd come to honesty with me. I didn't forgive her. That isn't mine to give, exactly. Forgiveness is for what was done to you personally, and the deepest wrong here was done to Gerald's memory and our children's inheritance, not only to me. But I didn't need to hold it either. Thomas came to help me sort Gerald's study the following spring. We spent a full weekend going through papers, 40 years of a careful man's careful life, filed and labeled and dated in his accountant's hand. Near the bottom of the last drawer, Thomas found a card Gerald had written and never sent, in the shaking handwriting of his last months. It was addressed to both children. It said, in 3 lines, "Your mother will handle everything correctly. She always does. I love you." Thomas held the card for a long time. Then he handed it to me. I kept it in the file, right behind the copy of the 2020 will, where it belongs. Gerald was right, and Margaret Calloway spent 32 years underestimating the woman in that sentence. I hope, if nothing else, the document examiner's report helped her understand the error. Claire tells me there's a word for what I did. She calls it quiet devastation. I prefer the technical term, due process. The numbers don't lie, the dates don't lie. And the woman reading the documents, it turned out, didn't lie either. If you've ever been written off as someone's footnote and watched them learn the cost of that mistake, you know exactly how that spring afternoon felt. Share this with someone who's been underestimated. And subscribe, because around here, the careful ones always outlast the careless ones.